easier than last night.
So we got everybody. Yeah, I broke it up better this time.
Yeah, I appreciated that because I got off track.
To have Steve Canfield take that position. That's all right with you, Steve?
Yeah, I'll do it. Yeah.
Okay.
Yeah, I'll do it.
I'll second.
Okay. Now, somebody want to close the nominations and then we'll just vote on it.
No. I vote to close the nomination.
Okay.
Make a motion to close the nomination.
Okay. All those in favor of me?
Aye.
Okay, looks like it's unanimous. Okay, now for vice chairman. Need a nomination? You want to do it, don't you, Seth?
Sure, am I it right now?
Yeah.
Okay.
Yeah. And see, you're lucky, I've never missed a meeting,
Yeah.
so you haven't had anything called on. So, yeah, I'll nominate you.
Okay, well, I'll second that motion.
There we go. I move we close the nominations. All those in favor of Seth as vice chair? Aye.
Aye.
Okay, it's unanimous. Now for secretary.
And it should be Marc.
Yes, Mr. Marc. You are by default, I think, so I move the nominations be closed and we all vote Marc.
Aye.
Secretary. Aye. Okay.
You guys are doing a fantastic job, so let's just keep the ship rolling in that direction.
Okay. Well, if you're happy.
Yeah.
Okay. Now, can we stand for Pledge of Allegiance? If you're able. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. First item, we need to have an approval of our August 2025. Man, we haven't been here for a while. Gee, Christmas, 2025 minutes. Have you all read them? Take a minute and read them. We'll just, when you're done, if you like them, make a motion. Oh, there's Tom. There he is. Hi, Tom.
He nominated you for president, Tom.
Oh, great. Yeah, and vice chair. So. You got two offices.
That'll teach you.
Yeah, yeah. So we're just reading the minutes. I need a motion to, if somebody will approve them.
I'll go ahead and make a motion to approve.
Okay,
Second.
okay. All those in favor? Oh, is there any corrections or anything? Before we, they look good to me, but I've slept since then.
Right.
Yeah, I know it.
Kinda crazy.
It's crazy. Okay. So if everybody's happy, please say aye.
Aye.
Okay, we have approval. Now, the other business is with our Mr. Taylor. Thank you, sir.
Your favorite part of the year, training.
Thank you, Dan.
It is designed to help you.
Like you, I was talking about this with the wife this morning. We started in 2019. Or is it?
Oh, yeah.
It's 7 years already.
Hard to believe.
That is unbelievable.
Yeah, hard to believe.
Mark?
It seems like just yesterday.
Yeah.
Okay. Well, I am going to challenge you a little this morning.
Uh-oh.
I'm not going to give you a test or anything, but I'm just going to try to, we're going to talk about three main topics in training. We're going to try to elevate what we do a little bit, partially just because we should, and partially because you may have some more difficult cases this year. Yeah, so you may have some, and I'm going to try to get you ready for that so that it's easy. And that's part of what I'm trying to do today. And then I'm going to talk about just some major things I always want you to remember that you've heard before, and then I'm going to talk about a couple new cases that were pretty insightful. So if you look at page 2, points of emphasis, this is where I'm going to spend most of my time today. We're going to talk about findings of fact, variance of use, and special exceptions. Those are our three main topics. So on findings of fact, it's just important that we understand what the law requires of our findings of fact. And so the law says that findings of fact must be specific. So when do you make your findings of fact? Believe it or not, you make your findings of fact when you make your motions. And so a proper motion is not, I move we approve, or I move we deny. It is, I move we approve because, and you go right to the factors, okay? Or I move we deny, and you go right to the factors. So today I'm going to talk about the art, I call it the art of making findings of fact. It's very, very important. Now look, if somebody comes in and they say, look, I need relief from this setback, I'm 3 feet over, you approve it, it's not likely at all that anyone's ever going to dispute that, and that case is going to be appealed, and it's going to go up to the Court of Appeals, and the Court of Appeals is going to say, I want to take a hard look at these findings. So most of the time, in what you do, we don't worry about this much. But I think in 2026, we're going to have a case, at least one case, where somebody might be looking at it pretty hard, so I want you to be ready. We're going to talk about that. So you can see in the Riverside Meadows case, the court says, look, your findings must be specific enough for us to know why you decided what you decided. Okay, so that's really the fundamental reason why we have to be specific. The Carlton case is a case, kind of a seminal case, or a really important case that all BZA people know, and that is, they said, look, if you make a finding and you just restate the factors, so if you say, well, I move we approve this because it's not injurious to the safety, morals, public health, and it doesn't have any negative impact on fair market value, and otherwise I just think it's okay. That's not good enough either. And that's what a lot of BZAs think, not just you guys, but all the BZAs I work with. They think if they just read the factors in their motion, that's enough. The courts say, no, that's really not enough either. Is you have to say why. And so when you make findings, or when you make a motion, and I've written one out for you a little later, you'll see how to do it. We have to be as specific as we can for each factor why you think what you think. Now, I would tell you that if we had a case go to appeal, and I've handled those before, not just your motion, but all of your discussion and the staff report and any information presented to you by anyone standing at this mic, that's all something the court is going to look at. So your discussion helps you because I can point to it and say, well, Judge, they didn't say so in the motion, but Mr. McClamroch said at this part of the discussion that he felt this way because of this, and that's the why. And on this factor, Mr. Hedrick said this about that, and that's the why, and the courts will let me do that, okay? but it's better if we just put it in our findings. So you'll see there, what are the keys to making finding? The first thing is ask questions, and then I want you to underline these words, okay? These 3 words, about the factors. So typically, it's, curiosity killed the cat. We hear about these cases, and we have all kinds of questions about what's going on, and we ask questions, and that's fine, but we also need to make sure that we ask questions about the factors. So if this guy says, I'm going to build a pole barn, and I'm going to do this, and we say, what are you going to do in the pole barn? And he's asking for relief from a setback, that's not really relevant. Now, I don't mind if you ask. And I remember one case we had early on, was a guy was going to have a woodworking shop in there, and we asked him some questions, and it was fine. But that's not going to help us. We need to know, why does it have to be 3 feet in the setback? Why can't you just move it? Oh, because there's a gas line there. Okay, that's a good reason. Okay, I get it now. So ask questions about the factors. Otherwise, the reason that we ask questions either of Marc or the petitioner, or sometimes the respondent, is because we're then making them tell us the reasons. Okay, so like in this case, if you said, why can't you put the building over there? That's a great question, great question. What do you think your building being closer to the property line is going to affect your neighbors? No, there's not a house for a half mile. I'm remembering this one case we had. Okay, well, that seems okay. So do you think that, this pole building being 3 feet over here is going to affect property values at all? Make them tell you, okay? Ask them that question. And then, go right through the factors. Now, each of the cases you handle have different factors, and we're going to talk about that in a minute. But use those as your guidelines, okay? I like to say in training, not in a meeting, but I'll say it in training, is if you wrote down the questions you had about a case, I would challenge you, go back and look if those relate, be able to tell me which factor your question relates to. Now, I have, Zionsville's one of my clients, and they're very strict and very sophisticated, and, they operate at a pretty high level, and inevitably, I keep notes, and that question does not relate to any of our factors. And I have one member and she's a lawyer, and she's the worst at it, and she wants to know, I swear to God, if it's a restaurant, she'll say, well, what's going to be on your menu? Because she can't help herself. Apparently, she just can't help herself. It's completely irrelevant, and are you going to have a drive-through? Now, when you have a you can have one of those double drive, doesn't matter, right? Doesn't matter. So you might just check yourself. Does my questions that I have, that I'm going to ask, do they relate to a factor? If they do, great. If they don't, then don't look my way when you ask it, because I might be shaking my head or something like that. So, okay, the second, state why the facts either support or do not support the findings. Okay, it's like I mentioned earlier. It's what I call the because. The granting of this variance will not injure, neighbors or public health because it's really not that big a deal. It could be that easy, So those are the 2 kind of guiding principles about asking questions and then making your motion fit. And then I've written you one. Okay, it says, you can see a compliant set of findings of fact will look like this. And you'll notice that I put in bold the word because. So in this case, I kind of use this small variance, 2 feet, will not be injurious to the public health, safety, morals, general welfare because the land to the rear of the subject property is undeveloped woods and a variance will not affect neighboring properties. Simple, right? The approval of the variance from the rear setback by a distance of 2 feet will not affect in a substantially adverse manner the use of the value of adjacent property because the variance is nominal and there's no adjacent property likely to be so affected. 3, the strict application of the terms result in practical difficulties, will result in practical because moving the house to the front of the lot will cost more due to unusual topography. They have to move more dirt. Now you remember, for a variance from a development standard, practical difficulty is the standard. What does practical difficulty mean? It means means difficulty, or it could just mean it would cost more money, and that's okay for practical difficulty. On variance of use, the standard is not practical difficulty, it's undue hardship. And I'm going to talk about that's a really high standard. But practical difficulty could mean, I remember when I built my house, my builder said, "Which side do you want your garage on?" And I said, "Oh, that side." And he said, "I wouldn't do that." I'm like, "Why?" He says, "I have to bring them to fill in over there, this end's higher, you want it on the higher end." I really didn't. Of course, he was right. He builds houses, I was wrong, but so I said, "Well, how much more did it cost me to put the garage on that side?" He said, "About $30,000. I said, "Okay, that side, let's move it over there, that'd be fine." And now that I've lived there 30 years, I'm really glad it is where it is. I just couldn't see what he could see. But that's what I had, was a practical difficulty. I did not have an undue hardship. I didn't. I had a practical difficulty, money. But that is what, so when you make a motion, you would say, I move we approve the variance for the following reasons. 1, 2, 3. That's what your motion should look like. Yes?
If the moving thing from one end of the house was just because of more money, then what is an undue hardship? You just said that wasn't an undue hardship, it was cost.
Right. I have a whole section coming up on undue hardship, so if you'll just hang in there with me. An undue hardship means that you can't put the land to reasonable use. That you can't use it. That's really different, as you can see. Yeah.
So I guess, Dan, would that be like, say somebody wants to build a house, like say in a waterway or something for a runoff of a field or something? Is that kind of, it's just not practical, just to put it there, is that what you're saying?
Well, the best example would be, because you're talking about a use variance. Okay, so use variance. Now, some of my clients have unnecessary hardship for variances, but it would be like the minimum square footage we allow is 1,800 square feet, but because of a creek running through the property, there isn't enough space to really build a house that big. So they want to build a 1,700 square foot house. They can make that work and satisfy Marc's drainage requirements, so they come to you and say, "I need a variance because I can't build an 1,800 square foot house because of the things going on my property." That's hardship. Yeah, that's different. That's not because I just want a smaller house. I want to save money. That's because I can't do it and meet all these other requirements. That's good, yeah. So let's talk about unnecessary hardship. Now, in your ordinance, the only time you'll see undue hardship is on variance of use. And variance of use is a little weird thing, because this is when somebody comes in and says, I want to put a Wawa in a residential area. And you're like, "Oh, you can't do that." "Yeah, but I really want to do that." So they have two choices. Wawa, I've dealt with them. They seem like nice people. Well, Wawa can rezone it, right? Or they could ask for a variance of use. And it's their choice, not ours, but they have to, if they rezone it and it's commercial, then they can put the Wawa there. And if they want a use variance, then they may just say, "I think I'll just try for a use variance." Now, why do they do that? Well, here's the why. If they try to rezone the property, they have to go through your plan commission and then go to your county commissioners. It's a longer process, and it's discretionary, so they may not know what'll happen. But a variance of use is actually faster, and they may just feel like they have a better shot with you guys. You never know. I see this all the time. Now, if I were the petitioner in a case like that, I would say, "Let me tell you why I'm not rezoning this, because if I don't end up developing this, you don't want this to be commercial. I'm saying just make it for us." A good example would be something we call a neighborhood commercial use, like Starbucks, could be Wawa, dry cleaner, something that the people all around it would use all the time. Neighborhood commercial is something you see this a lot. But if you get there, they're going to have to show unnecessary hardship. So what is it? So is you can see there at the top of page 3, there are 5 standards, so it's a little harder. Number 3, the variance arises from some condition peculiar to the land. So that's that creek running through the property or something else. Strict application of the terms of the zoning ordinance will constitute unnecessary hardship. And unnecessary hardship is the strictest standard. So if you go down to C, you'll see the definition. When all facts are taken together, the property cannot reasonably be put to a conforming use because of limitations imposed by the zoning ordinance. Courts have interpreted that to mean you can't yield a reasonable return. So the Beaver Gravel case is interesting because the Beaver Gravel case is a new case, came out of Noblesville, where it was an ag area, and the Beaver Gravel Company, guess what they wanted to do? They wanted to mine it for gravel. And the neighbors really didn't want that. They really didn't want that. So you'll notice there's no, in the name of the case, there's no municipality, but I can tell you it was the city of Noblesville. Valdovich was a neighbor, and Valdovich sued saying, oh, and by the way, and the BZA granted it. And the neighbor said, look, there's no hardship here. They could use it for ag. You can make a reasonable rate of return on ag. People do it all over the state of Indiana. And the Court of Appeals said, that's right. There's no unnecessary hardship there. Just because you can make more money using it as mining for gravel, that's not the test. That's practical difficulty, right? Hardship is, can you get a reasonable rate of return on this property if we don't grant this? The neighbor said, yeah, it could stay a farm. And the Court of Appeals said, that is exactly what we're talking about. The neighbor understands undue hardship. The BZA did not. It's really a strict standard. The next case I talked to you about is a case, Utica. In this case, it was, in the suburban areas, you see this a lot, but think about Hawkview, down south of town now. They're building all those houses. And so what the fire department wanted to do is they wanted to buy lot number 1 and put a really small fire department there called a substation. They want to put that there. And all they needed, there was already a house there, so they bought the house, and it was going to hold 2 firefighters at a time, and most houses could handle that. And then they just built this big garage that could handle a small fire truck. Well, they didn't ask anybody. So, of course, somebody came along and said, this is a residential district, what are you doing? And they went to the planning department and they said, can't we have a fire department there? And they said, nope. So they had to file for a use variance. They could have rezoned it, but they applied for a use variance. Now, again, if it were me, I don't represent people who appear before BZAs and plan commissions. I'm on the other side of the table. But if it were me, I would have said, you have to rezone that property because you're never going to be able to show what? Undue hardship. Never. Because we know the house can be used for a house. And you can rent that house and you can make a reasonable return. And in fact, using it as a fire department, how much money do you make on a fire department? Not a cent. And so in that case, they said, there's no hardship. Just because you can't use the property for what you want to use it for is not a hardship. So you can start to see how difficult it is. The only cases where somebody's going to be able to show hardship is they're going to be able to say, I can't use it for residential because it's in an the airport plan says I can't build a house here. But they'll let me build a warehouse. They'll let me do a warehouse as long as I don't put in a detention pond. I've had that case. And that would be undue hardship. I'm not allowed to build a residential neighborhood here. They don't want residences, but believe it or not, airports, they don't mind warehouses all around them. They just don't want residences. They're afraid a plane might fall from the sky and run into those houses, and it happens all the time, right? The other thing is, why don't they like detention ponds? Yep, geese. So they don't want any detention or retention ponds anywhere near an airport. And I've got clients who deal with that all the time. So what the courts have said is, it's really, can you make any return? You have to remember, every piece of land that comes forward in a petition like this already has some use, already being used for something. Ag, this gravel case, for example, is being used for ag. And you can make a return on ag most years, maybe not every year, but this year, maybe not every year, but in the long term, you can make a reasonable return. So it's not about rate of return, not ROI, it's just, or even a residential property has a reasonable use. Even if I live there, I'm getting use of it. I'm not making any money. Seems to just cost me money, but. So I talk about that because that is a high standard. So you have let's say one night you have a variance from a development standard, 2-foot setback, like I talked about before. That's easy, really pretty easy. Practical difficulty. Then somebody in the same meeting comes up and they want a variance of use. That's a big hill to climb, and we need to know that. We need to expect them to tell us why it is. So if you look at those 5 factors, the first 2 are kind of the same that you see in a variance for a development standard, but 3, 4, 5, are not the same. So you would say, what is the condition peculiar to the property that makes this unusual? And then they're going to say these words to you. They're going to say, well, your ordinance is the peculiar condition of the property. You say, no. And the court says that's not a condition peculiar to the property. Typically, it is something you can't overcome. A river runs through my land. There is soil I can't use, soft soils or something like that. There's a big woods there, and I really don't want to take down that woods, and that's the condition peculiar. I had one where the gas line ran right under. That's a hard one to meet. 4 is very hard. And then 5 requires a whole different level of thinking because the approval does not substantially interfere with the comp plan. Well, the comp plan is like 60 pages. That means you're going to say, well, how does, for example, how does the use of this land in mining, how is it consistent or inconsistent with the comp plan? Can you tell me what part of our comp plan you think talks about this? That's the question you ask. And do you guys have a copy of the plan? Okay, Marc, can you send it to them? Okay, you're going to need it. You're going to see why in a minute. You're going to need it. And I've done a little homework for you to make it easier, but it addresses a lot of things that you have to kind of know about. Okay. And you'll see, number 4, you'll see that the fact that petitioner can make more money is not enough. That is not enough. And that's what they'll tell you. And you'll say, that's great, but that's not really what we're looking for here. So that's a really high standard. I've seen it a couple times where it was granted properly, but most variance of use cases are denied. And then when you deny it, if you deny it, they can then go and file a rezone, which is what they should do. And the standard for that's a little easier, actually, just a little bit of a bigger process. Okay, let's talk about. No. No, there are bits and pieces of the comp plan they could say, but no, I would say no. And it's too busy, too much traffic, too disruptive. They're not really designed to be there. They're designed to be on corners of major roads. That's where they go. Sometimes they don't want to be there because that's the most expensive land there is on the corner. And if they go down the road a little bit, half a mile, it's a lot cheaper there. So you see that. Okay, special exceptions. Special exceptions are really hard. Now, what happens is you might ask yourself, well, what the heck is that? So when we put our zoning ordinance together, if there are uses that the county commissioners are worried about, like, oh boy, I don't know, these have impacts, then we generally require those to not only get rezoned, but to also come before you where you can take a good, hard look at it. And our whole thing is, we want to minimize impacts. So your job is to either say no to the special exception, or to say yes with conditions. And make sure that they do some things that mitigates the impacts. So I listed currently in your ordinance, there are 8 things which require a special exception. And as you start to look at them, this will start to make sense to you. Chemical manufacturing. Yeah, we probably want to know a little bit, we need to know some details about what chemicals, how you're going to handle them, what are the safety risks if you're handling this. But chemical manufacturing is very high risk. If you don't believe me, ask the people in India, they'll tell you. Fertilizer manufacturing, yeah. Nitrogen has a tendency to, and storage. So we want to make sure that's all being done the right way. Sanitary landfills, right? Testing towers, meteorological towers, waste transfer stations, wind energy. Again, the county commissioners aren't very favorable about wind, and they would want to have a rezone first, and then they'd have to want that applicant to come to you to make sure we're not hurting the neighbors. Wind turbines, carbon sequestration recently added. When that was added, carbon sequestration can only be in an industrial district. Not likely to be an industrial district now. It's likely to be rezoned from ag to industrial, and then it would come to you. So you can see all those things have impacts. So the criteria then is long. You can see we're used to we have 7, well, I call it 6 plus 3. We have 9 factors to look at on a special exception. So the first one is it listed as something that needs a special exception? Because that's the only thing you're going to see. If it's not listed in our zoning ordinance as requiring it, then you can't get one for it. So I'll give you an example. Data centers. Our ordinance, which was just passed Monday by the county commissioner, says you have to rezone that, but they did not require a special exception. They could have, but they chose not to. And the truth is, there are some impacts, but the commissioners are going to handle that during the rezone process. Power, water are the big impacts. And then number 2 is not injurious, which is something you have in all your other cases. 3, impact on property values, again, a factor you have in the others. Adequate services, the site will be adequately served by highways, sanitary, water, whatever. Negative community impacts, that granting the special exception will not create excessive additional requirements at public expense. 6 is if they've been denied, they have to wait a year. And then 7 are the tricky part, supplemental considerations. So the ordinance says, oh yeah, and by the way, when you're doing all this work, BZA, also think about these 3 things. First, in what respects does it meet the standards of the zoning ordinance and is compatible with surrounding uses? So this is compatibility. Is it compatible with what's around it? So you're going to have to look around, see what's around it. Secondly, the method by which the special exception makes adequate provision for public services, and that could be vehicular traffic, further amenities of light, air, recreation, and visual enjoyment. I'll give you an example. When Valero was built, had we had zoning, we would have a super highway going from 231 to Valero. Because that road is, Mark, can I use the word not adequate for the traffic? Yeah. And we would have required Valero, and I'm not picking on them, but we would have required Valero to build a staging area for their trucks. They really didn't. So what do? They back up all the way down our county road a mile sometimes. Not really what we want. But we didn't have planning zoning. Had we had it, and they needed a special exception, a good set of questions would be, how are you going to handle all this truck traffic? How many trucks a day do you expect? Where are you going to put them? Where are you gonna stage them? How long is it gonna take them to get through? And have you made plans for that? And you could have made them do a lot more to handle that problem. Light, air, clean air, like, again, some of the questions we would have asked Valero is, what are you gonna do about emissions? What could we expect there? And of course, they're regulated by the EPA, but we can still ask questions. And then C, whether the proposed special exception is in accordance with the general objectives and findings of the comp plan. See why you're gonna need a copy of the comp plan. And I will tell you, I did this little exercise, you'll see in a minute, I did an exercise for you, and it took me about 30 minutes to take my hypothetical and look at the comp plan, and I found like 7 or 8 references that were relevant. So it's a little bit of work.
I've just been thinking about what you're talking about with Valero and what you didn't get done back then. But I know Cargill is getting ready for a big expansion. Are we making any requirements for them to handle their traffic any differently? I mean, they're already, backing up the roads, clear across the highway, that break trains to get them through. I mean, what are we doing about that? I mean, does that trigger anything that we can require?
Well, they're zoned properly for their business, so we don't have any, no hearings there. What we can do is on development plan, build on that side, so they will need a development plan, which we haven't seen that yet.
See, again, they're grandfathered with their use, but they asked for tax abatement, so the county has asked them to address that issue. And I believe they will.
It's not just the county, it's also the city.
Yeah. But from a zoning perspective, they're already grandfathered. They have their right to do what they do. For an existing use, we can't take that away from them. But as a good neighbor, we can ask them to. Now, they do, I will say this, we asked them several years ago to tell their customers to come from the south. And they do that, and they do help with that a little bit. Of course, that just moves the problem to a different place, but the NDOT really did not want those trucks parked on 231, as you can imagine, so you have to remember, if somebody's there, they have vested rights, we can't do anything with them, really. And
I just wondered if a big expansion would trigger anything that we'd have to take a look at.
yeah.
Have one concentration. They just have one, and then instead of being trucks,
You're right.
we try to help that plan with the truck route, 800 going in there, and it has helped, obviously, with the 31. What it hasn't helped is the condition of the road. With 1100, obviously, there's a lot more traffic because of that, and a lot of it's static traffic. It wasn't real good when it started, 30 years ago, let alone just kept filling up.
And it,
Yeah, exactly.
And it's a really important business, provides a great market for our farmers, so we want to have a good relationship with them. But yeah, it'd have been a completely different story. Same with Nucor. I mean, Nucor, they've been great for us, but yeah, if we'd had zoning, things would have been a little different. You wouldn't see as much of Nucor. There would be these huge pine trees all around it, things like that, that visual would have been different. And we're fortunate they're a pretty good neighbor, and they've done a lot of what we ask of them. But we have seen plans for a new staging area. I'll just tell you, we have asked nicely, and they've been great so far, that they've heard us, and I think you'll see some changes there. Okay, and the other thing, at the bottom of page 4, you don't have discretion on a special exception. So you do have, even if on a standard, your 2 variances you have, if you think they meet all the criteria, you can still say no, as long as you have a reason. On special exception, if they can check all these boxes, you have to say yes. It's a non-discretionary item.
Discretion within the items, right? As far as
there is discretion as long as you have facts that support your discretion. So if you say, yeah, for example, visual impacts. If you say, boy, I just don't think this is what we want to see, and they've not mitigated that, and it's going to be a steel plant, and boy, if you're not going to put all those, screening out, I don't want it. You can do that. But yeah, you can't just say, well, you meet every box, but I just don't like steel plants. You can't do that. So you don't have to prove anything. Okay? They have to prove it. They have to prove there's no impact. And then now let's say they bring an expert. Let's say they bring some guy from Purdue in, an ag economist who says, the placing of a solar plant will have no adverse effects on ag values. I'm the expert in the United States on ag values, and I can tell you it's going to have no impact. And then a farmer comes up and he says, I live right next door, and I can tell you what, that's going to have an impact on my farm. Can you take what the farmer says? Yes. The law says every landowner is entitled to his opinion about his own value. Now, what remonstrators will often do is they'll bring a realtor with them who will say that. But the law says every person who owns real estate can say, I think this is going to hurt the value of my house, or I think this is going to hurt the value of my farm. But it's not your job, it's their job, somebody else's job, someone standing here at this dais to convince you or give you facts. Now, what if the facts are in dispute? So what if the expert witness from Purdue says no impact, and I've conducted a study and blah, 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 and you've got a realtor, you've got Greg Morrison from Montgomery County who says, I've been doing this forever, and it's probably how he'd say it. I've been doing this forever, and I can tell you it's going to be terrible for housing. And if you got a house out here, it's going to be worth nothing. Can you choose who you believe? Yes. Greg didn't do a big study. You got this guy, he's an expert. Can you choose? Yes, you can. You are like judges, and judges always get to choose who they believe. Okay, so you get to do that. We tell you you're a quasi-judicial. It is your job to hear conflicting information and decide who you believe. That's not exactly discretion, probably like you mean it, but that is part of your role, because sometimes people will disagree. Now, if you have a controversial case and you have 50 people in this room and they all have different opinions, you all decide the facts.
In that instance, where there's 50 people and there's two experts, and we hear it all, do we have the ability to pause, for lack of a better word, to discuss it amongst our five with you as our attorney?
Nope. You can ask Marc or me questions, but they won't let you take a break because they're convinced we'll go back there behind that gray door and we'll decide the case back there. But you can ask questions, and you can even ask the people who said something questions, and you can ask Marc. You can say, Marc, you're our planner, what do you think about this issue? You can always ask us, and we can't tell you what to do, but we can clarify things, or you could even say, I had one member once say to me, well, there seems to be a real dispute of this. I'm not sure. I am convinced either way. Well, the petitioner has the burden of proof to convince you there's no impact. So in that case, they said, I don't think you've met the criteria because you haven't shown me there won't be a substantial impact, and that's legal. That's fine. So that's a tough case, but there are a lot of cases. These lately in Indiana, the solar farms, these tens of thousands of acre solar farms have created a lot of things where the neighbors have said, this is going to kill my fair market value. And despite the 7 experts that the solar companies bring in from all over, the courts have said that the BZA can rely upon whoever they think. You don't have to be an expert. And also, the law says that you guys are experts in this. So that's one of the reasons we do this training, but you all do know, you all buy and sell it, you all know what land is worth. You all know, it's not like you were dropped yesterday on the earth. And so if you've ever purchased or sold real estate, you've got some information. And if it comes to ag real estate, you guys have some information on that too. So And that's good. That's good that you have that knowledge, so. Okay, if you go to page 5, we're going to keep talking about this, but now I'm going to apply it to a set of facts. Let's just say, hypothetically, that you have a carbon sequestration case come before you. You might. It's allowed under our zoning ordinance. Carbon sequestration, as you might know, is the injection of liquid carbon dioxide into the earth, a long way down into the earth, and it is used by high emitters of carbon to, they have to deal with their carbon somehow. So there's now a process where that carbon can be captured in the stack, liquefied, sent by pipeline somewhere else. And where it's sent to is, there are companies that have decided, you know, we can pump that in the ground. And it's a long way down. It is a long way down. I don't understand the technology exactly, but if you think about it, it's like what they do in fracking is they inject water, right? But they are going deep enough that they do not think there'll be catastrophic impacts. And so we are in an area where we have at least 2 pretty large carbon emitters, and we have one case which is currently being considered for a rezone for carbon sequestration. And so if they are able to get that rezone, they will be here for a special exception. Now, they may not get their rezone, and if they don't, you'll never hear about it. But if they do, their next stop will be you. So I want you to be ready, okay? Now, I'm not going to tell you anything about the facts of that case, because that would be inappropriate. So this is all hypothetical, so I can't answer questions about a lot of it. My job is to get you ready for what you have to start thinking about, okay? So now let's go back through those factors. How would you apply those factors to a case involving carbon sequestration? First of all, is it a listed exception? You already know the answer to that. What is it? Yeah, it's right there on the page prior. Yeah, not, good, John. Yeah, not injurious. So again, you're going to want to ask questions about, look, you're going to be injecting liquid CO in the ground, so are you going to have what looks like an oil well out there? Yep. Okay. Are there safety concerns in drilling liquid CO2 in the ground? On the surface, are there concerns? What about under the surface? What should we be worried about? Now, I will tell you that this process is regulated by the EPA, and it is also regulated by IDEM, Indiana Department of Environmental Management, and there are lots of rules. They have to get a federal permit first and then a state permit. And Marc and I have had to spend some time in this. It's a very thorough application process for those permits, particularly the federal one. So they have to submit a lot of information to them, and so by the time they get to you, they'll either have their permit or they won't, but they will have already submitted everything to the federal government, so there's going to be a lot of information available. So if you say, tell me about public safety, they should be able to talk to you about that. What are the public safety risks? What are the risks? Is CO2 flammable? Yes or no? What is the biggest risk? Is there a risk of fire, explosion, all the normal things we would think about? What about noise? What about lighting? How big is this place going to be? You know, how big is this thing going to be? How high is it going to be? All these things. So in this case, public health and safety are going to be the things you're going to want to ask questions about. Impact on property values. Here we go now. It will be their job to come to you with some evidence that this will not affect property values. These sites are generally across the country, they are generally in the middle of nowhere. So I doubt that it's going to be very close to anything, but we still need to look at that. And then think about how will it affect ag land and how will it affect residential properties. And they're going to have to show that. And so again, you should ask them, what is your opinion about how this will affect real estate values? They'll probably have a big study for you, okay? And then the neighbors will also have their opinions, and they may bring realtors if they want to remonstrate. Because they are typically far away from everything, we're not sure how much remonstrance we'll see from neighbors. Is that safe to say, you think? I think that's safe to say. But in addition to that, in every case like this we've ever had, whether it be wind or solar, you will have people from the public come in and they all have opinions about environmental impacts. We all do. Okay, so be ready for that. Adequate services. What is the site access? How do you get there? What kind of traffic are we going to see during construction and after construction? My guess is they are kind of like an oil well, and it is pretty quiet there, but I don't know. We need to ask them about their operation. Negative community impacts. So in the factors, it talks about this. So this relates to economic welfare of the community, the destruction or loss of natural, scenic, or historic features of major importance. I doubt that'll be involved, but now in the economic welfare of the community, if I'm the petitioner, and I'm not, but if I were, I would be coming in saying, let's just say they're going to take CO from Valero. I would say, this is how Valero thrives in your community and provides a good market and lowers their cost of operation. And so this is good for your local economy. And I think you're going to hear that. Okay, for any of these carbon capture programs, whether it be Nucor or Valero or any other large carbon producer, they're going to talk about how what they're doing is going to help your economy. And from an economic standpoint, they might be right. But they need to present you that evidence. 1 year sent to denial. We've never had a carbon sequestration request yet, so you know that won't be relevant. Now the supplemental conditions here get a little harder. So the first one on compatibility is, is it going to be compatible with what's surrounding it? Now, again, you're going to need to learn more and ask about operations to know what you're dealing with, but it may be a pretty low impact thing. If you've ever been around an oil well, they really aren't that impactful. So if it's like that, it's a small footprint, and it, doesn't, if it's maintained right, you don't even smell the oil very much, if it's maintained properly. But southern Indiana, in Illinois, we have a lot of that, right?
And I've got a quick question. This may be jumping too far ahead here, but so just like, for example, we ever heard of fracking, okay, and the people had where they could basically just turn the water on, take a cigarette lighter, and light the water on fire.
Exactly.
So
My friends in Pennsylvania would say, yeah, that's a problem.
So I guess going forward, like Tom said, what did it say, 30 years down the road, and, yay or nay either way on this, what is the liability / impact looking forward as far as the surrounding landowners have? If this thing happens, it blows up and does $50 million worth of damage and, hurts people bad, whatever, pollutes their groundwater, whatever. How does that look going forward compared to, just making a decision here going forward, say 10 years? How does that?
Well, you've heard the line, I'm from the federal government, I'm here to help you, but in this case, they are heavily regulated under what appear to be the two largest concerns environmentally. One, groundwater, exactly what we're talking about. How do we avoid the results that fracking had? And secondly, seismic activity. The other thing that came with fracking was seismic activity. So, and I went to school out in Pennsylvania, so a lot of my friends who were attorneys had to do with all that fracking. I think what they will say is, number one, we're going much deeper than those frackers. I think that's what they'll tell you. And secondly, they will say that they, in order to get their permit and maintain their permit from the EPA, there will be groundwater monitoring wells all over the place, not just on this site, but all over the plume area, which Marc is estimated to be a mile from there. So the federal regulations require them to install groundwater monitoring wells to be able to show us that there are no negative impacts. And if they have a measurement which exceeds, then they have to take measurements and notify the EPA. And so it's heavily regulated. And so they will present, that's something you should ask them. What about groundwater? What are you going to do? And I know they will tell you, because they have to submit an entire groundwater plan to the federal government, the EPA, and so they'll tell you about all that. But I know that, I've not seen it, but I know that the regulations require a really intense groundwater monitoring plan that has to be executed. Same way with seismic activity. Another big concern is, after fracking was, are people's houses going to shake? I mean, how's this really going to impact? So you should ask them to talk about that. I think what the industry says is no seismic activity that anyone will notice, might be measurable by a geologist, measurable, but nothing that would help. And again, all of that is regulated under their state and federal permits. So the good news for us on the local level is that we have a lot of help on environmental impacts. Does that mean nothing bad will happen? No, that doesn't mean that. But at least it's going to be very difficult to even get these permits, I think. And in fact, it may come, one of the things let's talk about, I know that Steve and Tom will know this, but for those of you not in the Plan Commission, you may not know this, so I'm going to teach you this, but so if they're able to successfully rezone the property, one of the conditions that I would expect would be imposed is you've got to get your permits, because our ordinance requires they have their permits before they move anything. Nobody in Montgomery County has a permit for one of these now. But it may be that if it gets a rezoning approval, that may happen. And they come in, they may even get a special exception approval from you, and it still may never be built if they can't satisfy the EPA and IDIM. And it's a tall order. I've reviewed the regs. It was not the most fun I've ever had. When we drafted our ordinance, we had to say, because we drafted it and they said, we were concerned about groundwater. So I had a whole section in there about groundwater, what I wanted, and they said, hey, I think if you've got one page here on groundwater, and I think if you look at the EPA's regulations, they're like 160 pages, and you might just want to refer to that. And so we did, because that was exactly right. Theirs were much stricter than even what we would do. So that's a great question. You should ask questions about all that, all of that. Make them prove to you. Be from Missouri. Show me that you've got it all under control. But we don't have to be the environmental gatekeeper, I guess, is what I'm saying, which is I'm really glad about, because that's not true always. But we get a little help we have really no help on wind and solar at all from the federal or state people. CAFOs, confined area feeding, we do get some help from IDIM on that, actually a lot. We just deal with CITUS, and they deal with all the environmental impacts. So what I'm glad to say is I'm glad there are real environmental engineers, geologists, people a lot smarter than me who have come up with a way to try to protect the environment and make them jump over that hurdle. Okay, methods. So again, you can ask them specific questions about all these things. I talk about light, air, recreation. It's raining a little bit. Is it snow? It's snowing now. Great. Great, I'm so excited. Comprehensive plan. So you flip to page 6. This is where I did your work for you. You can thank me later, because it was fun, let me tell you. Yeah, my wife sent me a text, where are you? And I said, I'm reviewing the comprehensive plan for she doesn't care. But anyway, I let her know. But in going through this, so I went page by page. Okay, does it say anything about carbon sequestration? Does it say anything about that's what I did. And I found some things. So first of all, on page 17, it lists what we don't want. I'm so glad that's in there, by the way. On page 17, in a box, so it's highlighted for us. In this little box here, it says undesirable land uses. industrial windmills, wind farms, industrial solar farms, commercial confined animal feeding operations. We don't want them. No, we can't stop them, but we don't want them. Landfills, junkyards, government subsidized housing. We don't want them. Hazardous waste management facilities, adult entertainment, heavy polluting industrial and waste transfer stations. Well, you'll notice carbon sequestration is not listed there, so what is that? So that tells us, well, it's not on the never do list, so maybe we're going to think about that. Preservation of ag land is a big theme in our comprehensive plan, and our comprehensive plan basically says we have a lot of the most valuable ag land in the United States, and we'd like to keep it that way, and we're going to do what we can to not lose that valuable asset. And so, again, how does that affect this? Well, this to me is where, how much area is this going to take? This, I can tell you, will probably be less than 10 acres. The footprint on these sites, if it's, depends on the number of wells, and I don't know how many wells will be involved, but generally it's smaller than 10 acres. And that would seem to check the box for, okay, it's not an ag use, but it also is not going to take up, you know, like Pulaski County, it's not going to take up 13,000 acres of ag land, right? So that's kind of a positive one. Increasing economic activity, I skipped because I already talked about that, but just coming back to that, we like things that increase economic activity, and so this site in of itself doesn't, but it may assist one of our major employers or our economic engines, and so that's something you have to think about. Number 4, impacts on groundwater. John, you're ahead of yourself again. Look at you. See, you're going to get a gold star. Impacts on groundwater is a factor discussed in the plan. We want to protect our groundwater. We don't want anything that's going to affect our groundwater. People are picky about their water, and they don't want it to be able to be lit and burn in your sink. And I knew a guy that's what happened to him. So we don't want that. So what, and you can see I wrote down, you know, I wrote like, what questions could you ask? What are the impacts of this project on groundwater? So one of you should ask that question. I've written it for you right there. What monitoring will the operation conduct? You see, this is me showing you in a hypothetical. 5, property values. What impact will this have on property values? And they have to tell you. And then, and the protection of property values, that's on page 33. I put the page numbers on the comp plan for you, so when you get it, you can check my math. And you can say, well, Dan said page 31, 33, 33. So these are important issues. And then the 6th one was ensuring, and I like this one, ensuring that future development decisions do not detract from the rural character and agricultural success. That is a specific goal of our entire plan. And so the question is, will approval of this project detract from the rural character or agricultural success? And I think what a petitioner like this would say, no, we are using a really small area, and it's actually going to help your farmers because you're going to get better prices at the market, or somebody else, or the vendor's going to make more money. One of those two things will happen economically. But it will, and it's likely to, first of all, it's likely to, if it's Valero, for example, that's being helped, it helps them be sustainable and stay here longer. It probably helps farmers get a better price, right? And so it's not just Valero, but if it benefits all of our local farmers, this is the argument they're probably going to make. And so that last factor on page 49, we'll need to ask questions about that. Now, for each use, where we go in the comp plan is going to be different. But I was looking, let's just say we have a carbon sequestration case. What in the comp plan looks relevant to me so we can answer that last factor? And you'll remember the last factor on page 4 is whether the proposed exception is in accordance with the general objectives of the comp plan. And the only way for us to know that and to know the questions we should ask is to go look at the comp plan. It's the only way for us to do it. In my history of doing this, this question is the one nobody talks about, and it is the one everybody should talk about most, in my opinion. Okay. The comp plan is not a law. but it is a vision of what we want in our county, and we spend a lot of work on it. We renew it every 5 years. We did one in 19, 24, this is pretty fresh, and we'll have other versions. But what the public told us when we did this is protect our ag land. And so if you think about what you hear about data centers, solar farms that exceed 10,000 acres, that's why those are not favored uses, because we're never going to replace that ag land. Now, does that mean we're right about that? No, that's just our position. That's just what our community decided. You could go to Boone County, and they obviously have an entirely different point of view about their ag land right now, right? Well, I'm not saying we're right and they're wrong. I'm just saying that that's our vision. And so you, as the BZA, are bound to look at that and say, okay, what does the comp plan say about this?
And then those comp plans, is that a public copy?
Yep.
Does every county require, are they required one that state is recommended? And then do these, in this instance, the carbon sequestration company, they've got these for all these counties, and they're looking for the softest one.
That's exactly right. Yeah, they are required by law. You can't have zoning unless you have a comp plan first. They don't want us to be shooting in the dark. So the law says you have to have a comp plan first, then you have to have zoning. Jay County tried to have zoning before having a comp plan because they were hurrying because they wanted to prevent a landfill, and their whole ordinance got thrown out of court. So the courts, they said, but I'll paraphrase for you. When we say you have to have a comp plan first and then have zoning, we mean it. So yeah, you have to have it. They're all public, and you're right, they shop around. Now, it's interesting. So what are they looking for? You're right, they want to go somewhere where carbon sequestration is not on the naughty list. We have a naughty list, they're not on it. And they want to go somewhere when they look at the zoning ordinance, our zoning ordinance is not so obviously against it that they might have a chance. And I'll come back to that in a minute. And they need a carbon producer. So like, Gary, like Nucor obviously could benefit from a carbon capture program of some type. Valero could, and there may be a few others, but those are probably some of the bigger ones. So if they looked at our county, what I think they'd see is we're not on the comp plan. It's not anti-carbon sequestration. On our zoning, it is not like solar and wind where you have to rezone to a special district. You have to make it industrial, but the message, and you have to get a special exception. So I think the message to someone on the outside looking in would be, well, it's not on the naughty list, and there is a pathway, and it's still going to be tough, but we might be able to thread that needle. Now, it's funny because if you looked at, I'll just say solar, if you looked at solar, a person who is in that development field should be able to look at our ordinance and say, take them off the list. But we still get inquiries, and we may still have cases. And I find that surprising because when we adopted it, I got calls from, we were the first county to do it the way we did it, which was to say, nobody is allowed to build solar or wind. Nobody's going to be able to do that. And we just adopted the same approach with data centers. Nobody has a right to do that. If you want that right, you're going to have to rezone to a special district for that, and you're going to have to go, and our 3 county commissioners will make that decision, and they have discretion, and if they say no, you lose. That's what we did with those. This is not one of those. Did we say it's permitted? No, we didn't say it's permitted. We said it's only permitted in industrial, and they're not going to go in an industrial area, I don't think. And then we said you have to get a special exception. So again, this is what I call middle hard. Not impossible, middle hard. And so I think that's a message. They do exactly that. So what they do, they need carbon, right? So you go to some counties don't have a lot of carbon, but you need a carbon emitter that needs help and is willing to pay for it, and they will pay for it because it saves them. They have to deal with that carbon one way or the other. It's much easier to do this than to haul it off, because they're going to build a pipeline to do that, and then they need somewhere to put it in the ground, so they need to find some landowner who will let them do that. Now, if you're a farmer and you have 500 acres, it's all kind of contiguous, there might be a spot. It's all brand-new technology. I don't know if it'll work yet, but if it does. Solar is a little different issue, because solar, again, we thought of solar, we thought we knew what solar was, but then, you know, they're thousands of acres. And I would have never imagined that that's what we'd be talking about. But 13,000 acres in Pulaski County is the big fight up there. Vermilion County, I've consulted with them, and they've got 5. They have one project, one that is already there. They have a second one that's in approval or denial right now, and they've got 3 more coming. And that's not that big a county, and they're all huge. So I'm trying to figure out how, you know, 7 miles wide, can I drive all the way across it and not get past the solar? Is it all gonna be solar? I just don't know. But we'll see. Okay. If you go back.
So as far as the question, so on page 3, it says only allowed on industrial district.
Correct.
So it does have to be rezoned.
Unless the situs is in an industrial section. Okay. If you look back, the rest of it is you're familiar with. I just want to draw your attention to a couple of things. The rules of what you are, I would like you to review this stuff, but I'm just going to hit on a couple highlights. So if you go to page 10, I have given you for each of the 4 cases, you also have administrative appeals, but the 4 types of cases, I've given you a good little primer, really good little thing I'd carry this training thing with you when you come to these meetings. It's like a little Bible. But a little section for each of those and how they're different and what the factors are. If you go to page 14, you'll see administrative appeals. And all I'll say about that is, I had one of these recently, but that's when somebody, you know, Marc says, if Marc says that is a structure, for example, is a deck on a house a structure? It is actually, but some people want to argue about that. And if they think Marc's an idiot, they can appeal to you. So that's called administrative appeal. And Marc's not an idiot, so. Page number 14, 5 there, or 4, I've got like best practices. Disqualification, I know you guys know, but if you have a financial interest, you can't participate, you just leave the room. If you tell me I can't be unbiased because the guy who's coming here is my mortal enemy, then you just disqualify yourself, recuse yourself. But in most cases, you know, we know everybody. You're going to know people. That's not the problem. It's just if you can remain objective about it and you don't have a financial interest, you're good to go.
If you're an adjacent property owner,
Yep.
do you have the right still to communicate?
You do, unless you believe that you're not disqualified automatically just because you're a neighbor. You're not. And that's the Burton case. It's cited right in for you, and that's not enough. If you don't have a financial interest, the question would be, can you be objective and impartial? And if you believe you can, and what if you know the people? Like, again, the Burton case, which is solar out of Madison County, they said, look, it doesn't matter if you know the people involved. It doesn't matter if you have coffee with them or you're a member of the same church. None of that matters. It's whether you can be impartial. And if you say, look, I know Bill and I know Nancy, but I can sit here and do my job, that's all we care about. Good question. If you go back then, I'd like you to go back all the way to page 23. And 23, I've already talked about the Beaver case, 21, which is that what is an unnecessary hardship. But 20 is also interesting because in that case, this had to do with 2 fighting recyclers in Monroe County. And in that case, the Plan Commission granted use variance. And then under considerable pressure from someone, probably the competing company, sought to revoke their approval. And their lawyer even thought they should revoke their approval. But the Court of Appeals said, no, there's no process for that. in your ordinance, you decide the cases, and you can't later, a month later, say, ooh, we really messed that up, we're gonna reconsider that and change our mind. Now, I will tell you, we lawyers who practice this area, we did not know the answer to this question. We did not know. No one had ever heard of this before, but the Court of Appeals took a really easy way out. They said the statute doesn't say you can, so you can't. So in order for the BZA to reconsider a decision that's made, the state legislature would have to give you that authority. They haven't given you that authority, and there's a whole section of laws that apply to you guys. So probably it's a correct ruling, but, so don't get that idea. If somebody contacts you after a meeting, says, I think you guys messed that up, and you need to change your mind, you have to say, well, our job's done. You can take our decision to the courthouse, that's where it goes next. But you guys are, you gotta wash your hands of it, so.
Well, that's where you come in, and make sure you guide us into not making a major.
Right, right. Well, you guys have been great so far. You haven't any trouble, so, but yeah, I think in 26 or 27, we might have some harder cases, so that's why I wanted to try to cover this stuff with you. But yeah, I'll be right there. I'll help you. Mark and I'll help you. Are there any questions? I've gone a little long, sorry.
Well, yes.
Okay, thank you.